thought it'd be a good time today just to take us through some of the changes that have been made to employment law. I think most of them have been in force since the 6th of April 2024, but we're still in the kind of infancy of them coming in, so it's a good time just to catch up on what's changed. And as we go through, I've got to a point now where I have reviewed a few policies and made some updates in all these areas. So if there's any kind of practical things that I think I can point out of how you might actually adopt these into your policies, and I'll point them out as we go through as well. So try and get through quite a lot this morning. We'll go through first of all the changes that have come in from the 6th of April, because they're the ones that you really have to have in your policies just now. So we'll touch on the flexible working changes. I think we did a full breakfast brief on that in January, but that was more flexible working requests as a whole. So I think it will still be useful just to go through what specifically has changed to the flexible working legislation from April. We'll have a look at changes to paternity leave that have come into force in April as well. There's actually been a full new type of statutory leave introduced in April as well, and that's the statutory carers leave. So we'll go through that in quite a bit of detail, just what that looks like, how I've saw other people implementing that into their policies as well. And then we'll just do a kind of very quick update on changes to redundancy protection. That's more of a smaller change in law. And then there's another kind of big change coming into force in October 2024, but I think it might be one that you might have a bit of groundwork to prepare for in advance of that coming in. So I thought in today's session, we'll look at that and look at steps you might want to take just now ahead of the new sexual harassment legislation coming into force in October as well. So first of all, just what's updated to flexible working requests. So this has been enforced from the 6th of April. It looks like quite a lot, but in practice, when I've been going through and updating policies, it's really just a few tweaks policy-wise, but worth highlighting. So the first one I've popped down there is that there's now going to be no requirement for the employee to outline to the employer how they think that the change they're requesting is going to impact the employer and how the employer might deal with it. So before, with the flexible working legislation, when they made the request, they might have said, for example, I want to go to a 4-day week. I think this might impact because we'll be short on a Friday, but I think you could deal with it through there being enough overtime staff on. So that's just a very rough example. But now when they're making their request, there is no requirement at all for them to say, I think you'll, sorry, I'm just going to pop that in mute. There's no requirement for them to say how they think it's going to affect you and how they think you're going to deal with it. They, in essence, just need to put the request in, and it's up to the employer to make that assessment. So I've seen in quite a lot of the standard forms that people have for their employees to request flexible working, there's a box and it almost says, what do you think the impact is and how could they deal with it? So if you have any sort of boxes or requirements for employees to put that information in, that can be removed. The next one's just that it's a day one right. So previously they required 26 weeks continuous service. Now that's going to be a day one right. So essentially someone could start working with you and in their first week of employment, try out the working arrangement. And if they want to make a change to it or there's any flexibility they need, right from the get-go of their employment, they can make a statutory flexible working request. So that's quite a big change. The next change that the new regulations have put into force is that now an employee can make 2 requests in any 12-month period. So beforehand, they could only make 1, which meant, if in any rolling 12-month period they made a request, they would have to wait another 12 months before they could make another one. But now it's going to be 2 requests they can make in a 12-month period. So where I've kind of saw this come up in policies that I've reviewed is sometimes it will set out the eligibility criteria for someone to make a request, and what it will say is like A, be an employee, B, you've not made more than one request in the last 12 months. And I also see it in the forms that some employers have in for requesting flexible working. Sometimes they'll have a declaration to say, I confirm I've not made more than one request in a 12-month period. So I would just go through and do a sense check to make sure that any references you have to the max number of requests are now 2. The next one is that the decision must be made within 2 months of receiving the request. This was previously 3 months. It might be worth going and seeing historically how long it does take you to, complete these requests from the moment you receive the request to when you give the outcome. But now what the statute's amended to say is that they must be dealt with within 2 months. Sometimes these can be a bit more complex. Maybe there's some consultation going on, looking at different arrangements. If you think it's going to take you longer than the 2 months, what you would just be required to do is, in writing to the employee, notify them that you're going to need an extension to the 2 months, and just communicate that to them. But it's probably just worth being a bit more vigilant on your timescales now that they've been shortened. And then the last one is that if you're rejecting a request, so in terms of flexible working requests, the 8 business grounds, so things like unable to meet customer demand, if you remember the grounds that you can reject a request, these haven't changed. They're still the same with the new legislation. The difference is that if you're using one of these grounds to reject a request, you now have to consult on alternative arrangements with the employee before rejecting. So in practice, this might actually mean that you have more than one meeting now for a request. So beforehand, you might have had the meeting when they put the request in writing, listened to their points, went away, looked into it, and then you could have rejected in writing or accepted. But now, it might be worth having another meeting before you reject, just to come back to them and say, we've looked into this. We find that, we're going to have to reject what you've proposed based on these grounds for these reasons. And it might be that a second meeting's more helpful to do that consultation. It might be that you consult and there's no other option and you still have to reject it. But I think having some sort of second meeting somewhere in your process might help with that. Even if you're just adding kind of wording into your policy to say, we may require further meetings to fully consult on your request, just to give you a bit of provision to have more meetings if you need them. So that kind of completes the changes to flexible working requests. Again, if anyone's got any questions, we'll have time at the end for that. But the key ones are just that it's a day one right. We don't have to give any outline of how the change will impact the employer. 2 requests in a 12-month period now, not 1. 2 months to make the decision, and you need to consult on alternatives now if rejecting. So moving on to carers leave, and I'll try and take us through this just in a bit of detail because it's a completely new type of leave that's been introduced. So this has been it received Royal Assent, the Act, last year, but the regulations that actually bring it into force have been in force now since the 6th of April 2024. You'll get the slides afterwards and I've hyperlinked it, so if you actually want to go on and see what they look like and how they're set out, you can do. But what they basically do is give employees a statutory right to take 1 week of unpaid leave for those with caring responsibilities. So I think this one came in off the back of a lot of work that was done through government consultation on people who might work a full-time job, but still have unpaid caring responsibilities for dependents. So this leave's been brought in to try and give more support to employees who might have these extra caring responsibilities out with their employment. So because it's been designed to kind of help with that problem, the leave can be taken in full or half days. I think the rationale behind that is that, a half day might allow them to, say, take a dependent or a family member who they care for to a hospital appointment on a half day, or they might need a full day. If there's been some sort of emergency, they need to care a bit longer term, they can take it up until the week block, and it's unpaid. The regulations do say that they need to give notice. So the notice they say would be the earliest of twice the amount of leave. So, if it's a day, they need to give 2 days notice or 3 days in advance. So whatever's the earliest of that will be the notice they need to give to take that carer's leave. And if you go on and look at the regulations, they do set out scenarios where they give the power for the employer to postpone the leave, not quite refuse it, but if the period of leave's coming at a time where it's going to be, I think they use the word business disruption, you can write to them and give them notice that you want to postpone the leave. And the wording that they use is that you would consult on a new day for them to take the leave. So I've just put this down because one thing I found quite interesting about the new carers leave is that if you look at how they define a dependent, so the people who can use this leave are those who have caring responsibilities for a dependent, and you'll see that the first two is just your spouse, civil partner, child or parent, and the second one's someone who lives in the same household as you, but it's not, you're not the landlord or that sort of arrangement. But that last one, C, it says anyone else who reasonably relies on you to provide or arrange care for them. So I'd say that's quite wide ranging. They're not putting specific labels of certain family members. It just says anyone else who reasonably relies on you to provide care, which I think would probably capture quite a lot of relationships. So it's worth noting that if someone comes and makes a request for this type of leave, and it's not their direct child, mother, I think that catch-all C means that it probably will capture a lot of employees and a lot of different caring relationships. And then another, when I read through the regulations, another thing that was within there that I hadn't seen in a lot of the kind of news articles and things about this leave was just how you calculate a week's leave. So what they said is they've split it up for those who work regular hours. So, someone who's on a fixed hour contract works the same amount, 37 hours per week. So the number of days that they'll receive for their 1 week's leave will just be what they normally work in that week. Or, say they're part-time, they always work 3 days in that week. A week for them will be the 3 days to get the week off. But they've given us ways to calculate a week's leave if someone has no fixed hours. Because obviously if someone gets the week's leave, but every week they kind of work slightly different hours, or 1 week they work more, 1 week they work a lot less. What they've said is that you would work that out by looking at the previous 12 months, what they normally work in a week, and dividing it by 52. So that's going to work out similar to how you would work out an annual leave calculation. So just looking back at the last 52 weeks and working out from there what they normally work in a week, taking an average. And then they've said if you might have someone who's requested this leave who's been employed for under 52 weeks, and what they've said there is that rather than dividing by the 52 weeks, you would take what they work with the weeks they've worked for you and divide it by the number of weeks they've been employed. So if you've had someone who's been in less, they don't work fixed hours week to week, you would just use the number of weeks that they've been employed for. So that takes us through the new statutory carers leave. And if anyone, if you take our services, we've got a kind of policy drafted up for this, and happy to look over any wording that you might have put together for carers leave. So next, also coming into force on the 6th of April 2024 was the paternity leave amendment regulations. And these changes impact parents whose babies are born after the 6th of April. So that'll be, any babies that are being born for fathers and partners who are in your organisation now. These changes will be implemented for them if you follow the statutory scheme. So the kind of historic position on how fathers and partners could take their paternity leave is that they can take one block of leave. So they can pick whether they want that to be 1 week or 2 weeks, but they can only take that leave in one block, and they would have within the first 8 weeks of the childbirth to take that 1 week block. So I think there was some government consultation on this, which called for just a bit more flexibility on how fathers and partners can use their leave. Because in essence, if someone only takes the 1 week block, they're forfeiting a week of paternity leave under the old scheme. So what they've done in response to this is they've just altered it and made a kind of adjustment so that it can be taken a bit more flexibly. So now the actual leave itself, the entitlement to statutory paternity leave itself hasn't changed. It's still 2 weeks that they receive. It's just how they take it. So now it can be taken in 2 non-consecutive blocks. So rather than only having to take 1 week or 2 consecutive weeks, they can now take 2 weeks in 2 separate blocks, or they can take still just a block of 2 weeks. So what that means is they can get 2 separate weeks off, and they can take this any time in the 52 weeks after childbirth. So that's quite different to the previous, where it was within 8 weeks of the child being born. It's now going to be 52 weeks. So any time in that 52-week period after the child being born, they might make a request and say, okay, so I want the week after the childbirth off, and then maybe a few months later they want to take another week, and there's now provision in the law to do that. So because now they can take leave any time in that 52 weeks, what they've added in the regulations is some wording to say that they have to give 28 days notice to the employer in respect of each period of leave. That just means if they're not taking their paternity leave straight away, they want to take it maybe a few months after the child's born, they can't just come in, and say, I'm going to go off and take that 2 weeks paternity leave next week. It says they have to give 28 days notice before they go on that period of leave. Again, they might put it in advance and let you know the blocks that they want to take within that 52 weeks. What the regulations say that is if they want to change the date, they also have to give 28 days notice to the employer to change the date. So in practice and policies I've seen, the main changes will just be where it sets out the leave, it will normally say, you can take a block of 1 week or you can take a block of 2 weeks within 8 weeks. So now it would just need to be altered to say that, they can take these blocks unconsecutively. And then I would also add in something just to say that they need to give that 28 days notice before they take a period of that leave. It's likely worth highlighting as well. You'll remember that the current position is they have to give notice 15 weeks before the expected week of childbirth, just that they intend to take paternity leave and for paternity pay. That's not changed. So they still have to let the employer know 15 weeks before the child's born, that they intend to take paternity leave and use paternity pay. The 28 days notice is just 28 days notice related to taking that specific leave. So the notice requirements that they're actually planning on taking the paternity leave, that's not changed. It's still 15 weeks before the expected week of the childbirth. So the next one is a smaller change, also coming into force on the 6th of April 2024. We were lucky on that date. And this is just an extension of a previously existing employment law. So the legislation, again, I've hyperlinked that if you want to have a look at it, but it's the Protection from Redundancy, Pregnancy and Family Leave Act 2023. And what that basically does is extend the protected period that mothers on maternity leave or on adoption leave experience in a redundancy situation. So if you remember, the previous position is that if you had someone on maternity leave or adoption leave, for the period that they were on that leave, employers were legally obliged to offer them suitable alternative employment first when there's a redundancy situation. So they, in essence, would skip the queue and be looked at first. And if there's a suitable alternative position there, they would be offered that. That's not changed. All that the new legislation has done is they've extended that from 18 months to 18 months. So rather than it just being the period of leave itself, it's now going to be 18 months from the first day of the expected week of childbirth. So what that'll probably basically mean in practice is if you do have a redundancy situation, you would normally do some sort of exercise at looking at those who are on a period of family leave. And from that, you would be looking at who's on leave in terms of suitable alternative employment. But now you would be looking potentially at those who are back in employment who've come off leave because that's been extended to 18 months. And the last one I just wanted to take us through, because as I was going through it, I thought it might need a bit of work from members just in advance of this coming in, just to do a bit of assessment on where you are with this to get to where you need to be in October. So this legislation's received royal assent, and at the moment we're kind of told it's going to come into force in October of this year. So that's the Worker Protection Amendment of the Equality Act 2023. And what that does is it's going to require employers to take reasonable steps to prevent sexual harassment in the workplace. So I think when this was first coming around as an idea, we spoke about this in a previous webinar. And at that time, what they proposed it was going to be was that an employer must take all reasonable steps to prevent sexual harassment. It's now gone kind of back and forth from the House of Commons and the House of Lords, and the word all has actually been removed. So now it's not that employers must take all reasonable steps. So in essence, every step possible. Now the legislation that's coming into force is now just that they must take reasonable steps to prevent sexual harassment in the workplace. So this is going to be a legal duty that you must be taking some steps to prevent this from happening in the workplace. And what will happen now is that if an employee raises a claim to the Employment Tribunal for any sort of sexual harassment, and the tribunal look at it and find that the employer wasn't taking reasonable steps, they can put an uplift onto the compensation awarded. So it will have an impact in a financial sense if you fall short of this and you perhaps end up in some sort of Employment Tribunal claim to do with sexual harassment. I think that'll work quite similar to the ACAS statutory code at the moment. So if you remember, if an employer doesn't follow the ACAS code on disciplining grievances at the tribunal, they can put an uplift onto the award if you fall short of it. So this will act in a similar way. If a tribunal finds that you didn't take these reasonable steps to prevent it, they can add more onto the compensation. So I was just having a think about what reasonable steps might be, just so that you can have a look just now, maybe do a bit of a review and think, if we were to find ourselves when this legislation comes into place, well, we have enough in place so that right now we can say that we're taking those reasonable steps, and that you can just be in a good position. I think probably the key ones just to get you started on this and make sure that you're taking those reasonable steps is just having a look, having in place some organisations will call it an anti-harassment and bullying policy. Some it will be contained within your equality, diversity and inclusion policy, but just some policy that sets out the expectations, provides some sort of reporting procedure for complaints of harassment. So I would just go and have a look at what you have in place in terms of these policies just now. Maybe a good time to look at it and have a bit of a refresh just to make sure that it's hitting those best practice points, that it's fit for purpose. As well as just having that policy in place as well, I'd probably want to, in advance of this, just make sure that it's sitting somewhere that's accessible to employees, that employees know it exists. Whether I don't know if there's some sort of way in your organisation that when this comes in, you can highlight and just give a bit of training to your employees on the policy you have in place and what it means, why it's in place, how they can use it if they need to. And then also just a kind of wider thing of, in your training requirements, do you have any sort of regular training on equality, diversity and inclusion, or harassment? So just trying to incorporate that into the training that you're giving to employees and that you're refreshing that. As well, it might be a good time to just take a risk assessment, find any areas of risk, go through that, and just to be able to demonstrate that you've done that risk assessment for your organisation, I think would be helpful. And then another one's just reviewing your reporting procedure. So what is your specific reporting procedure for someone who might have this type of complaint? Do you have a separate reporting procedure within your anti-harassment and EDI policy, or are they referred to the grievance procedure? And just making sure that you're investigating all those complaints thoroughly. So it's not come into force yet, but in advance of it coming in, I would say it's probably just a good time to just do that kind of exercise of going through everything you have in place just now, and having a think about whether or not you're in a position where you're taking those reasonable steps to prevent sexual harassment in the workplace. So as promised, a lot to run through this morning, but hopefully that just gives you like a good overview of what exactly has come into force, and probably just some points that you probably need to go away now and have a check of. Does anyone have any questions at all this morning?